Well, good evening. Tonight is Sunday, September 24th, and the time is 9:22. Okay. I had told a lot of you on here that watch this, watch my um, videos, and I appreciate it for you that do. Please disseminate it as needed. But I was telling you guys this last past Friday, a couple things that I was going to share with you, so that one that I'm doing for my case and my next case that I'm going to file, and this is very uh, legal, legit stuff that can be used against tribal courts, federal or in federal court, and against states that are possibly abusing and violating your civil rights, constitutional rights, parental rights. But let me get right into the first one. One of the ones that is probably going to, and it applies to, again, state, federal, and tribal. So this is one of the ones that I already sued under, or that I am currently suing under right now, the Yakima Nation Tribal Court individuals. Section 242 of Title 18 makes it a crime for a person acting under color of any law to willfully deprive a person of a right or privilege protected by the Constitution or laws of the United States. So again, this is Title 18, Section 242, deprivation of rights under color of law. For the purpose of Section 242, acts under color of law include acts not only done by federal, state, or local officials within their lawful authority, but also acts done beyond the bounds of that official's lawful authority. If the acts are done while the official is purporting to or pretending to act in the performance of his or her official duties. Persons acting under color of law within the meaning of this statute include police officers, prison guards, and other law enforcement officials, as well as judges, care providers in public health facilities, and others who are acting as public officials. It is not necessary that the crime be motivated by animus toward the race, color, religion, sex, handicap, familial status, or national origin of the victim. Whoever under color of any law, statute, ordinance, regulation, or custom willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States. So again, this applies to tribes, it applies to states, and it applies all the way across the board here in the United States. So don't let them BS you on some of these tribes that say sovereign immunity, because that's all it is BS. They're just trying to bully you. And that's how bullies work. The next one is Title 18 USC 241, and it's conspiracy against rights. They're in effect as of today, and so they're valid. Again, 241, conspiracy against rights. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, they shall be fined under this title or imprisoned not more than 10 years or both. So again, that's Title 18 USC 241, conspiracy against rights. Some of you may ask, well, and this works for people that are on reservation or off reservation like me, that don't reside or domicile, their kids don't reside or domicile, and that's such. So it's not just a tribal measure. It's a federal law that all states and tribes must abide by. It's not a discretionary thing. They're mandated, required, and they have to abide by it. This one is for both people off reservation and on reservation. So this is as it reads. Quick reference sheet for state court personnel. U.S. Department of the Interior, Bureau of Indian Affairs. Final rule, Indian child custody proceedings, 25 CFR 23. All child custody proceedings, they have to figure out if this child is eligible for membership in a federally recognized tribe and has a biological parent who is a member. Then they have to figure out, they determine, well, the domicile or residence of the child or parent Indian custodian is on a reservation or in an Alaskan Native village. Those don't apply to me. They don't apply to anybody that lives off reservation. So don't let them fool you, play stump the chump with you. Determination of jurisdiction. The Indian child's tribe has exclusive jurisdiction over the case if the Indian child's domicile or residence is on a reservation where the tribe exercises exclusive jurisdiction over child custody proceedings, or the child is a ward of tribal court. Neither myself, Crystal Buck, our children reside or domicile on the reservation, and our children are not wards of the tribal court or the state or the federal government. So, again, they want to use exclusive jurisdiction. Well, they can't, simply because of the fact, this is coming from the BIA. The same thing mirrors it in ICWA, Indian Child Welfare Act, and the same thing that mirrors it across the board, 25 USC 1911, 25 USC 1901, UCCJEA, RCW 37.13 and 0.18. So there's no jurisdiction that the Yakima Nation has. So all they're trying to do is wait it out and see. And they're not. They're gonna lose. They're gonna lose, and they're gonna lose big time, and they're gonna end up giving me $3 million. Some of you have said, well, my tribe or the state or something, specifically in this part of it, tribe, the tribe will play games with you just like they're doing with me, but I've exhausted all means. I've had appeals that are still ongoing, and from 2.5 years ago, dismissal from 2 years ago, all this stuff going on. And then they'll say, well, you haven't exhausted all means. You don't have to exhaust all means. That's a bunch of garbage that they try to tell you, and they try to lie and press upon you. But I'm going to read this because it pertains specifically to exhaustion of means. The 4 recognized exceptions to the requirement for exhaustion of tribal court remedies are: 1, an assertion of tribal jurisdiction is motivated by a desire to harass or is conducted in bad faith. 2, the action is patently violative of express jurisdictional prohibitions. 3, exhaustion would be futile because of the lack of adequate opportunity to challenge the court's jurisdiction. Or 4, it is plain that tribal court jurisdiction is lacking. Burlington Northern Railroad versus Red Wolf 196, F3D 1059, 1065, 9th Circuit Court out of Montana, 1999. So that right there, I meet all 4 criteria and all 4 elements. That doesn't mean you have to meet all 4 of those elements. You just need to meet one of those 4 elements. Mine in particular is the whole thing that it's motivated by desire and it's being conducted in bad faith. But either way, it still shoots them down. Like I said, I don't know who the hell they think I am, some ignorant or some idiot that doesn't know how to read. But this will help you guys out going through my trials and tribulations. I hope this helps you out doing these things. Furthermore, in that reading, which will take me on to my next thing about suing individuals within the tribe. The release sought against an individual in an official capacity suit is nominal and in fact seeks relief from the sovereign itself. Yeah, that's true if you do certain things, but you have to, and this is how I'm going to show you how to do it. In a true individual capacity suit, however, a plaintiff seeks to impose individual liability directly upon the government officer for actions taken pursuant to law. And they use this example: Hafer versus Mello, 502 U.S. 2125, 1991. Case law: Edelman versus Jordan, 415 U.S. 641, 663 to 665, 1974. In the latter suit, the real party in interest is the individual, not the sovereign, and therefore sovereign immunity does not apply. In Lewis versus Clark, the court found that the individual capacity suit against Clark for a tort committed while operating a vehicle within the scope of his employment on state lands would not operate against the tribe, ID at 7, or disturb the sovereign's property, ID citing Larson versus Domestic and Foreign Commerce Corporation, 337 U.S. 682, 687, 1949. That is the same Lewis v. Clark thing where it was en banc, that meaning all the judges were there and they voted unanimously, judged unanimously 8-0 against the tribes. The court next considered and rejected the argument that the tribe's indemnification of Clark under tribal law affected the immunity analysis. What indemnification means, for you folks, and it's not to think that you're not intelligent or don't know, but indemnification just basically means that they're protecting them. They're shielding them because they're an employee or an official within the tribe. So that's all that means. But let me read that again. The court next considered and rejected the argument that the tribe's indemnification of Clark under tribal law affected the immunity analysis. While conceding that the tribe ultimately would, quote, pick up the tab, end quote, for Clark's defense, the court concluded, this is the Supreme Court, concluded that the state court's judgment would not bind the tribe or its instrumentalities in any way. ID at 910. In other words, the tribe's indemnification or shield of Clark would not convert the suit against him into a suit against the sovereign. And it did not purport to determine the tribe's indemnity obligations. ID at 10. Finally, and this is really good, really big for you folks. Finally, the court suggested that tribes do not automatically become a required party for joinder purposes under Federal Rule of Civil Procedure 19, simply by virtue of indemnification of the defendant. Again, finally, the court suggested that tribes do not automatically become a required party for joinder purposes under Federal Rule of Civil Procedure 19, simply by virtue of shielding the defendant. That's a huge thing. So that means that they can't sit there and say, oh, well, because he's a tribal member or she's a tribal member, that they have sovereign immunity. Nah, bullshit. They don't have it. They're lying to you. So with that sovereign immunity too, and how you can go about things, and these are rules of law that come from federal law that are incorporated and sent into states, and states adopt some and they disregard others, or but for the most part, they have to incorporate into rule of law. So this is coming out of chapter 2, for chapter 2 of the Spokane Lawyers Association, and it deals with tribal authority. So here, I'll show you this. So if you try to look it up or research it or get it, copies of it, you know what you're looking for. Chapter 2, Tribal Authority. Subchapter 2, the powers of Indian tribes. Immunity of tribal officials, employees in federal and state courts. What I'm going to tell you and what I'm going to read specifically from here is the stuff that I highlighted that pertains to my case and generally pertains to 99% of your stuff or your issues that you know. And again, knowledge is power. So here goes. A, immunity of tribal officials, employees in federal and state courts. A, the official or employee is an official capacity suit or an individual capacity suit. So when you go in there, you and the courts and whoever else, they either argue or recognize, okay, is this an official capacity suit or is this an individual capacity? I don't want to say you couldn't sue a tribe, but it's going to be a lot harder of a hill for you to climb. I mean, that might take you decades to do that as an individual suing it. So that's mainly for government to government or organizations that would probably be able to do that because they have the unlimited resources, billions of dollars to do something like that. But anyway, B, the following principles generally govern claims brought against tribal officials or employees in their official capacity. Now, there's 3 sub-paragraphs to that. But again, the one I'm going to focus on deals specifically with my case. And again, Yakima Nation Tribal Court, that turd Ethan Jones, who works for Office of Legal Counsel, who's not supposed to be representing tribal members individually, but he is. So they're violating their own laws still continuously. And, everybody's just has this cognitive dissonance about it. But anyway, in this part 3 of this subsection, it's 3, claims for prospective, injunctive, or declaratory relief to prevent violations of federal law are generally not barred by the tribe's sovereign immunity. So they're violating federal law like they're doing in my case. They're not barred from sovereign immunity. They can't play that trump card. They can't do it. It's just, when they're violating federal law, which is, Constitution, civil, things like that, then it waives their sovereign immunity. The following principles generally govern claims brought against tribal officials or employees in their individual capacity. 1, an individual tribal official or employee, rather than the tribe, is the real party in interest as to claims brought against the official or employee in a personal capacity seeking either prospective relief or retroactive monetary relief. 2, tribal sovereign immunity does not apply. Let me read that again. Tribal sovereign immunity does not apply to individual capacity suits. 3, the fact that a tribe has voluntarily bound itself to indemnify, which means shield, protect, officers or employees held individually liable for claims will not cloak the individual with a tribe's sovereign immunity. They might have personal immunities, but, it doesn't indemnify. If that personal immunity is there, well, then go back to deprivation of rights under the color of law, which is going to cover this. So any immunities that they have are a joke. Here's some of the comments. Comment A, real party in interest determines capacity sued and available immunities. Any lawsuit brought in the federal or state courts naming a tribal official or employee as a defendant. When the tribe is not the real party in interest to a claim, the tribal official or employee is not entitled to sovereign immunity. Now, these are rules of law. This is legally what they have to do, the courts. Federal statutes may affect immunities available to tribal officials or employees sued in the federal or state courts. But again, goes back to deprivation of rights under color of law. That's 18 U.S.C. 242. Tribal sovereign immunity in official capacity suits. Tribal sovereign immunity does not, in general, bar actions for prospective, injunctive, or declaratory relief against tribal officials or employees in their official capacities to prevent violations of federal law. C. Personal liability of tribal officials and employees and immunity defenses. Tribal officials and employees sued for damages in their individual capacities are not imbued with tribal sovereign immunity, and a tribe's voluntary decision to indemnify a tribal official or employee held individually liable will not shield the officer or employee with tribal sovereign immunity. Another highlighted part of this. Otherwise, the lawsuit proceeds against the tribal official or employee in his or her individual capacity, or sometimes referred to as a personal capacity. The remedy is sought only against the individual. See Lewis 137, SCT at 1291 through 1292, Pister 79, filed 3D at 1112 through 1113, and Maxwell 708 F3D at 1088. Now, some of these are case laws, so you're going to have to, stop, rewind in order to get some of it. But here you go. In Santa Clara Pueblo versus Martinez, 436 U.S. 49, 1978. The Supreme Court, citing Ex parte Young, 209 U.S. 123, 123, 28, SCT 441, 52, LED 714, 1908. That's 1908. Held that a tribal official could be sued for prospective injunctive relief to prevent a violation of federal law, the Indian Civil Rights Act, CID at 59. The federal courts of appeals that have considered the issue uniformly hold that the principles of Ex parte Young apply by analogy to tribal officials, and therefore that tribal sovereign immunity does not bar claims for prospective injunctive relief against a tribal official allegedly acting in violation of federal law. See example Crow and Dunleavy PC 640 F3D 1140, 1154 through 1155, the 10th Circuit Court, 2011, alleging violation of federal common law. Second case is Van versus Kempthorne, 534 F at 3D 741, 749. That's in the DC Circuit Court in 2008, alleging violation of Indian Treaty. Burlington Northern and Santa Fe Railroad Company versus Vaughn, 509 F3D 1085, 1092 to 1093, 9th Circuit 2007, alleging that enforcement of tribal tax would violate federal law. Some reading. I haven't read this guy yet, but I'm going to try to look him up. See generally Richard B. Collins, To Sue and Be Sued, Capacity and Immunity of American Indian Nations. 51 Creighton L. Rev. 391, 414 through 416, 2018. Discussing Supreme Court cases involving declaratory or injunctive relief against tribal officials and the application of the Ex parte Young doctrine. Comment C in Lewis v. Clark. The Supreme Court held that a tribal employee was sued in his individual capacity and that the tribe was not the real party in interest. ID at 1290 through 1292. Personal capacity suits seek to impose individual liability upon a government officer for actions taken under color of state law. Hafer, 502 U.S. at 25, page 112, SCT 358, and the emphasis is added. Officers sued in their personal capacity come to court as individuals. Hafer 502 U.S. at 27, 112 SCT 358. And the real party in interest is the individual, not the sovereign. ID at 1291, emphasis in original. Additionally, the fact that the tribe had enacted a law requiring the tribe to indemnify tribal employees in these circumstances was not sufficient to make the tribe the real party in interest. ID at 1292 to 1294. Stuff like that happens, and tribes try to do that, and they didn't come right out and say it, but tribes have in fact done post facto law. And post facto law happens quite a bit on tribal reservations. It's highly illegal, and people can read through that stuff. Judges with enough judicial experience and common sense can read that. So, for instance, they might have a law saying you can't do something. Well, you don't do it, but then you do something else that they try to construe. And so even though you're ticketed for whatever it is you did, then they create a law afterward, means post facto law. And then they try to, come back. That's highly illegal. They can't do that. Other cases recognizing that tribal officers or employees are subject to suit for damages when sued in their individual capacities include Maxwell versus County of San Diego, Pister versus Garcia. Tribal in that one it reads Pistor versus Garcia. Tribal officers sued in their individual capacities for alleged unconstitutional detention and seizure under color of state law and in concert with state law enforcement officials cannot assert sovereign immunity from suit. Garcia versus Aquasasni. This one's I hope I'm not murdering the name, but anyway, this one happened in Second Circuit Court in 2001, and it allowed tort and discrimination claims for money damages against tribal employees in his individual capacity to proceed. The Supreme Court and lower federal courts have separately made clear that individual tribal members do not enjoy sovereign immunity from suit. See Puyallup Tribe Incorporated versus Washington Department of Game. They basically, what it was is holding individual tribal members are not protected by tribal sovereign immunity. United States versus James. Ninth Circuit, 1992. Tribal immunity does not extend to the individual members of the tribe. As the Ninth Circuit has explained, the fact that a lawsuit seeks damages arising out of the actions of a tribal official or employee within the scope of his or her employment is of no moment for the purposes of determining whether sovereign immunity bars the action. Pister, 791 F3D at 1114. Noting that the parties misapprehended that whether an official acts under color of state or tribal law is wholly irrelevant to the tribal sovereign immunity analysis. The court continued, by its essential nature, an individual or personal capacity suit against an officer seeks to hold the officer personally liable for the wrongful conduct taken in the course of his or her official duties. As an officer personally is the target of the litigation, she may not claim sovereign immunity, and that is so regardless of whether she was acting under color of tribal or state law at the time of the wrongful conduct in question. So, again, this is all ammunition for you. Don't let them fool you. Keep coming back to these videos. School yourself up on this stuff. The biggest thing is whether they're an officer. An officer means an employee within that tribe. And they can be absolutely held accountable for those things. Even if they try to sit there and come back and say, well, they're in the official capacity and they're an employee and we're going to indemnify that tribal employee. No, it doesn't happen, especially because a lot of tribes, what they do is trample all over Indians and non-Indians' rights. And when that, whether they're in an official capacity or an individual capacity, but let's say they hold some seat of authority or power or something like that. What happens is when they act outside of that stuff under the color of law or outside their individual authority for that position that they're in, when they act outside that scope of authority, boom, it's automatic wave of sovereign immunity, and it's a wave of their rights to sovereign immunity. So you have the knowledge, you have the power. Please keep coming back for more. Again, ask questions. I hope you have a good Sunday night. I did. And I pray that you don't have to go through what I have or what I am going through. But I will win in the end. I'm going to persevere. I will prevail. And when that happens, boy, I'll be sitting, my children and I will be sitting a lot richer. So good night. You guys have, I'll see you. I'll post again, probably tomorrow or the next couple days, but hang in there and love you guys. God bless. Peace.